I can take it off if we need to, but. All right. Good morning, everyone. It's January 21st at 9:01 a.m. The meeting is called to order. First item is to do a roll call. Dr. Bruce Podoli.
Here.
Patrick Bazzini.
Here.
Michael Coble. Dr.
Here.
Michael Coble, excuse me. Mr. Mark Daniel.
Here.
Dr. Nancy Downing.
Here.
Dr. Jasmine Drake.
Here.
Dr. Sarah Kerrigan.
Here.
And I don't know if Mr. Jarvis Parsons is remote or he's just not here. Okay, so he's not here. All right. Item number 2 is the review and adopt of the minutes from the October 22nd, 2021 Commission meeting. If everyone's read that, do I have a motion to accept and approve?
Motion to approve.
Second?
Second.
All those in favor say aye.
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 Opposed? Motion carries. Item number 3 is the office administrative update. Lynn?
So the main things, the budget, I'm gonna take my mask off just to speak, if that's okay. Can everybody hear me?
Yes,
Okay.
ma'am.
So we put a budget status report in your materials. It includes updates for current revenue from licensing. So we are in quite good shape there. We've adjusted the budget based on expenditures from travel from the last meeting and accounting for the fact that we had 3 commissioners not present, so we've done the best we can to anticipate what travel will be. There will be additional travel that we didn't have last year because Robert, Lee, and I are all going to the Academy meeting, and that's quite an expensive meeting. But we are attending that this year. And then budget-wise, we don't really have major updates. We had an expense for Dr. Rohrig on Expertox, which was actually, he did an incredibly thorough job on the report. It's in your materials, and I thought it was well-priced, given how much work it was. We paid the bill for ETL drawer to do the training, and Lee will get into that in a minute. So those have been our major expenditures other than staffing. So nothing major there. If you have any questions, I'm happy to answer them.
Is there any discussion or any questions? Okay, nothing else on that?
And then we have, just for the other things, so I was on a panel for the Appellate Judicial Education Institute Summit that happened in Austin this year. It's actually for judges from around the country, and they came here to Austin and did a bunch of training, which was great. And I was on a panel with Barry Scheck and Russell Wilson from Dallas, who I know a lot of you know. He was the first conviction integrity chief that they have, and the Chief Justice of the Oklahoma Court of Criminal Appeals, David Lewis. We did a panel talking about essentially how forensic science plays a role, what we can do to improve forensic science in the context of wrongful conviction. It was very well attended. It was a plenary session, and we got a lot of good feedback from the judges. We had federal judges, state court judges, some appellate lawyers as well. So that was good. And did you want to say anything about the drawer training? One thing we put in your materials, thank you to Mickey Pierce, we have slides that show who attended that training, from which forensic disciplines, and it was 2 days. One was for all disciplines, the second day was focused on DNA analysts. But it was very well attended between people who went in person and those who were online. So we were happy to see that because it felt like the money, it used to be that ETL would not do anything online. And so we couldn't really, like if we had 60 people in a room and his fee was X. That was just the way it was. So it was actually quite a high price tag per analyst. But now that we were able to do it remotely, it worked out quite better financially, I think. Mickey, did you have anything about that, or?
Yeah, it was about over 400 people that were able to attend since we were able to offer it remotely, and 16 agencies I think about attended. So, and the feedback, I was the feedback was overwhelmingly positive. Everyone enjoyed it and got something out of it. Even people who have seen this stuff before, these obviously been around for 100 presenting. So we were really pleased and really grateful that the commission was able to help us put that together. So thank you for the
So yeah, we were happy about that, and we can, consider doing it periodically if we're able to continue this hybrid approach. And then the final thing is that you can see the timeline for rollout of the various aspects of our database project. The programmers are working night and day on it, and we expect to go, they're going to be finishing writing the code within the next couple of weeks. Then they'll move on to internal testing for their group. Then we will test it. Then the labs that volunteered to pilot it will pilot it, and then it will be launched. So we're thinking somewhere around the April timeframe. And it is very complex and very sophisticated what they're building for us. So we're happy about that. And grateful to OCA for giving us those, what would otherwise be probably cost prohibitive for us, because just hiring those programmers for that length of time would be hundreds of thousands of dollars. So. Yes, so that's everything on admin. Did I leave anything off, Lee, or? Okay.
All right, any further discussion on that? Any questions? All right, if not, let's move to item 4, which is Mr. Daniels' presentation on complaints and self-disclosures.
Thank you, Dr. Bernard. We have today, coming from our October 2020 meeting, 11 new self-disclosures, 3 complaints, and then 4 matters that were resolved administratively by staff, which they are authorized to do. The first item is, look at that number, it's 1750. It begins back in 2017 from the Houston Forensic Science Center. They had disclosed an incident from the forensic biology section where they had multiple local CODIS case hits that they found out that no notification letter had been provided. The laboratory became aware of this after receiving questions from a submitting agency about some familial hit that connected a couple of cases, and they realized that proper notification had not been done in that case. They set about to conduct a very thorough audit. They reviewed 601 hits and found that 474 had not been notified, and they fell in 3 categories, which we have in our materials. The laboratory did confer with Gary Molina, as you know, who's the state CODIS administrator, and he had found that ultimately the lab took all the necessary and appropriate corrective action that it should have done. This kind of goes back to August of 2017, where the commission had reviewed the matter and found the laboratory performed a thorough and root cause analysis and took the appropriate action. But they provided us in October with a finalized corrective action report after multi-year work and audit. And as a result, they've modified 1,060 profiles. As a final corrective action, they identified 2 primary contributing factors as root cause issues. And one is pretty basic, just a disconnect between the former CODIS administrator and the CODIS community standard practices. And then they didn't really have a CODIS function responsibilities being assigned to a single individual, and they've since done that. As always, our staff did a tremendous job reviewing this matter, investigating it, and had made a preliminary recommendation that possibly no further action is necessary. Any questions, comments, or concerns? If not, I'm prepared to make that in the form of a motion that we take no further action in connection with our item 17.50.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which would bring us to our second disclosure, which comes out of the Tarrant County Medical Examiner's Office. It's item 21.51. This came to us back in September out of their seized drugs section, where they found an extraction error because an analyst had used a concentrated glacial acetic acid instead of the 6% standard of glacial acetic acid. The lab discovered the error and did a re-extracted sample using the correct concentration. They also retested the sample in a gas chromatograph, resulting in a positive test. They amended the report, reissued the report, and provided it to the customer. As they looked at the root cause and the source of this, they found the analyst simply did not review the psilocin and psilocybin mushroom extraction from the lab's published materials procedures in performing the extraction. And essentially the analyst had somewhat of a lack of understanding of the significance of deviation in the concentrated glacial acetic acid instead of the required 6%. Their corrective action was provide further training and to focus on the need for analysts to review the analysis procedure prior to performing any procedures. They did look at other cases and found no other cases were impacted. Again, our staff had done a tremendous job reviewing this and had come to us with a preliminary recommendation that we also take no further action in light of the work they did in the root cause and also the corrective actions by the lab. Any questions, comments, or concerns regarding that matter? If not, I will make that in the form of a motion that we take no further action.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which would bring us to our third disclosure. It's item 21.56. It comes out of the Houston Forensic Science Center, their firearms and tool marks section, where an analyst had inadvertently switched two sets of Nibin test fire bullets from two separate cases and then packaged the bullets for each case into essentially what was the wrong case file. The lab set out and determined which two affected cases had been identified, but the test fire bullets were not labeled in accordance with the firearms section's SOP, and so they did new test fires were created for each of the cases. We understand the Nibin technician is no longer with the lab, has not been interviewed concerning the matter. When they were doing the audit and review, they found a second case that also had discrepancies. They found one item in a case to only have two test fire bullets instead of what they expected to find three. And they found a second item in the same case to only have two test fire bullets, and one of the bullets did not appear to have been packaged in the same case. They essentially found a little bit of a systemic lack of labeling for both test fire and bullets and cartridge cases with that analyst's work. They expanded their audit, and the Nibin technician's test fires were also reviewed in all the cases where his test fires were potentially used for comparison by a firearms examiner. And as the date of the self-disclosure, they'd found 5 other cases that required additional review. They did just 2 weeks ago provide us an update as to the self-disclosure, and then identified cases where the technician's test fires were used in at least one comparison, and they reviewed the original risk assessment and reevaluated all the risk levels. They did communicate this to HPD property room to ensure their firearms are currently available, were not destroyed or released for further testing, and their corrective actions pending on it with regard to our case review, as we've already discussed. The matter's been vetted substantially. Staff had made a recommendation that there be no further action. Staff did assure us they would review the lab's final corrective action plan and advise us of any concerns that come out of that. But with that being said, any comments or questions or concerns about that item?
I just have one question. Was it the same technician with the second issue, or is it somebody different?
The same technician.
Okay. All right.
Any questions, comments? If not, I will make that the staff's recommendation in the form of a motion that we take no further action.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which would bring us to our fourth matter, which comes out of Austin PD Forensic Science Bureau, their seized drug section. They reported an incident that during a quality audit of their gas chromatograph libraries, they discovered an Analyst had found an incorrect lot number for Utilone standard in 2 different gas chromatograph instruments. And the laboratory's technical leader further discovered the lot number missing from an NN dimethylamphetamine after review of the affected cases, and discovered essentially 3 incorrectly reported cases. It all resulted from the LIM system with a drop-down menu that they had 2 substances that all began with an NN, and there was probably a human error in checking the first one that their eyes came across. The lab did review a sampling of cases that reported the DMT, which is a far more common substance. Sure, no errors in that group of cases. 91 cases reported the compound all the way back to 2007. They're in the process of reviewing those cases and will report back. They have notified the Travis County DA's office, the United States Attorney's Office for the Western District, and also the Austin PD of the issue. It looks like a human error from the drop-down menu. Staff had reviewed the matter carefully. They are going to request a copy of the lab's final report and update us of any issues of concern, but at this point in time, staff had brought back a recommendation to us that we take no further action. So any comments or questions or concerns? If not, I will make that in the form of a motion that we take no further action with regard to item number 4, which is case 2158, non-disclosure, disclosure case 2158.
Is there a second? All those in favor say aye.
Aye.
Opposed? Motion carries.
Which brings us to our 5th disclosure, which is case number 21.64. It comes to the Tarrant County Medical Examiner's Office Tox section and Seized Drug section, where toxicologists had inadvertently switched 2 case samples and effectively reported incorrect results for each case. The lab discovered this after the chief toxicologist got an email from the referring agency that questioned some negative results for what was believed to be alprazolam based on known facts of the case, which I suspect is simply viewing it. And around the same time, the quantitative results for alprazolam in another case did not correlate with the screening data for unreported cases, so they essentially the cases have been run next to each other and essentially switched. The lab retested both samples, concluded the samples were switched in the extraction step. They have reviewed all cases in the same batch, which consist of 36 cases, and cross-checked those results, finding no other discrepancies. And they have now provided additional training for staff to hopefully alleviate the problem. Staff had brought forth to us a recommendation of taking no further action, which I concur with, but any questions, comments, or concerns? If not, I will make that in the form of a motion that we take no further action given the root cause analysis, the case review, and the corrective action taken by the lab.
Is there a second?
Second.
All those in favor say aye.
Aye.
Motion carries.
Which brings us to our 6th disclosure. It comes from DPS Houston Seized Drugs Unit. It appears the lab had inadvertently destroyed some seized drugs due to some lack of defined instructions by the submitting agency on how to determine when they should be destroyed. Back in June of 2021, the Houston lab received a disposition of seized evidence report from the Woodville, Texas Highway Patrol, some assistant there, indicating the case was closed. And the Woodville, Texas Highway Patrol requested the lab dispose of the evidence. The lab did so following its standard procedures for destruction of evidence and issued a closed without analysis report back in the summer. And then they sent that on to Hardin County DA's office and the Tyler County DA's office, and everybody said whoops. So they had advised that the Woodville, Texas Highway Patrol issued the authority to destroy the evidence was actually an error. The laboratory ceased destroying evidence cases immediately at that time, requested a list of all the authority of evidence to be submitted. The Woodville, Texas Highway Patrol has since revised their process so that a commissioned DPS employee that has a rank of sergeant or higher is now authorizing the destruction of items not submitted for destruction only. And the crime lab has also updated its policy with the same and communicated this to the DPS laboratory system. So hopefully that would alleviate this from occurring again, but based on the root cause analysis, the case review, and the corrective actions by the library, which was simply a mistake, staff had made a recommendation taking no further action. And would there be any questions or comments or concerns about that item? If not, I will make that in the form of a motion that we take no further action.
Is there a second? All those in favor say aye.
Aye.
Opposed? Motion carries.
Which brings us to our seventh disclosure. It's case 2166, which comes out of the Houston Forensic Science Center, their forensic biology unit. They reported the staff had inadvertently consumed some left-hand fingernail scrapings and clippings when performing testing, but way back in 2010. And they said it was at the request of the Houston Police Department Homicide Unit, where permission was only given to actually consume the right-hand fingernail scrapings and clippings. The lab notified HPD Homicide Unit, who indicated the inadvertent consumption did not negatively impact the case, and the original results had yielded a single source DNA profile that belonged to the victim. And the second round of results were consistent with the original results. The lab determined that that section had not performed some independent verification of obtained permissions to consume. The lab has now since revised its request for re-extraction worksheet to incorporate a review of the consumption of evidence samples. The lab also revised its DNA general procedures to require a specific request for re-extraction worksheet be completed and verified by an independent analyst prior to destruction of evidence. And when the permission to consume is granted, a documented review of the communications surrounding the consumption as well as the confirmation is now being performed. The lab did provide us just a few weeks back an update. They've explained that part of its continuing quality investigation, they're reanalyzing cases from a second screening analyst, and will do 24 other cases. Based on the root cause analysis and the corrective actions by the lab, staff had respectfully made a recommendation of taking no further action, which I concur with. And anybody have any comments or questions or concerns regarding that item? If not, I will make that in the form of a motion to take no further action at this time.
Is there a second? All those in favor say aye.
Aye.
Opposed? Motion carries.
Which brings us to our eighth item. It's case 21.67. It comes out of the Barrett County Criminal Investigation Lab, their forensic biology unit. They had reported an incident in the lab where analysts had utilized a nuclear fast red chemical beyond its laboratory designated expiration date. In all fairness, the chemical actually did not include the manufacturer's expiration date on the label, and the lab also had designated its own expiration date of 10 years after opening on those chemicals. And no analyst had previously been tasked to evaluate the expiration dates on chemicals within that defined period. In response to this matter, the lab discarded the expired chemical. They opened a new chemical for utilization. They did additional testing, found no visible staining difference. They don't believe there was any risk to cases where analysts used that expired chemical. They've now clearly labeled all previously opened chemicals with an expiration date, and also assigned a forensic biology DNA analyst to evaluate all the chemical expiration dates every 6 months. They've also placed a log sheet in front of each chemical reagent logbook, which must be initialed and dated as to the chemical's expiration date. It looks like that will not happen again. Staff had done a very thorough job on this and come forward to us with a preliminary recommendation of taking no further action. Any questions or comments or concerns about that item? If not, I will make that in the form of a motion to take no further action.
Is there a second? All those in favor say aye.
Aye.
Opposed? Motion carries.
And just last month, our next item came to us, 2168 from the Bexar County Criminal Investigation Lab. They had found an incident in the firearms section where an analyst reported that class characteristics on cartridge cases could come from Generation 4 and Generation 5 Glock pistols. But the report should have only listed the Generation 5. Additional reports were found to have the same incorrect wording, and so the lab set about to issue what was required, amended reports. In its root cause review, the lab certainly spoke with the analyst. The analyst reported she had recently started reporting in this manner, surmised that she was confused by the Glock models 42 and 43 being included in the 5th generation of Glock firearms. The lab went back and looked at 7 months worth of reports from May to November of last year. The lab discovered 3 additional cases referenced in which it had to issue amended reports. The analyst will not in the future report the specific generation of Glocks because it's not necessary for what the stakeholders require, and it looks like they have made the necessary corrections. Staff had brought forth a recommendation to take no further action. Any questions or comments about that item? If not, I will make a motion to take no further action.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which would bring us to item 10, which comes out of
We missed one, number 8.
No?
No, I think we
covered that.
did. Yes, ma'am.
10.
And let's go to 10, which is MS Labs out of Horsham, Pennsylvania. The lab discovered an error in preparing substocks used in validation of a special investigation bromozolam case study and other testing that followed. The Quality Control Department generally prepares the stock standards in the lab, which the research and development scientist then uses to prepare a substock used in analysis. In this instance, the scientists prepared the substock solutions incorrectly, which caused results to be 10 times higher than they should expected to be. The lab discovered the error when another lab brought to its attention that 5 samples are roughly off by a 10-fold factor when compared to other laboratories' values using that same method. The lab set about to find out what the problem was. In the root cause analysis, they discovered the validation and testing processes used were really not adequate to support the utilization of the process. The special investigation process lacked 2 components. One was verification that substock preparation is completed successfully, and 2, that the quality control in the process to assess calibrator performance and validation of the routine performance of the special investigation testing. Their corrective measures are they updated their standard procedures to include a verification instructions and expanded on the imprecision bias studies to include a level of quality control material. They also performed a level of quality control check with each run and reported patient values to ensure some quality and spiking material. They sent us a list of all their affected cases, and all those supporting materials were included. It looks like it's been corrected. Staff, in their thorough review, had made a preliminary recommendation to us of taking no further action. Does anybody have any questions or comments about that item?
I have a question. I'm not sure if there's someone from NMS here, but it wasn't clear to me from the corrective action. Their corrective action is to begin to include a quality control sample each time they're running cases or patient samples. That leads me to believe that they were not running a quality control prior to this, and I was wondering if that is standard practice with their quantitative analysis. Is this limited just to the bromozolam?
I would have to, is my mic on now? Is that better? Sarah, I would need, Dr. Kerrigan, I would need to follow up with NMS. So we can either, I can follow up, we can table it, or I can follow up and get you the answer, and if it needs to be reintroduced, we can. Because I gather from the question is you would have expected it to have been run previously.
Yeah, it's pretty standard practice to include a quality control to verify your calibrators every time you're doing a drug quantitation in toxicology. So I don't have a problem dismissing this one, but I think that we would want to know if that is the practice with other assays.
I can definitely reach out to NMS. To be totally fair to them, they asked if they should, attend the meeting, and I mean, everybody's sort of worried about COVID right now, and they would have to travel from Pennsylvania, so I said, that if there was anything that needed attending to, we can do it between meetings. So I think Dr. Logan would have been here, except that I told him he didn't need to come, so I will follow up with them and let you know what they say on that question.
Thank you.
Would anybody have any problem tabling that till we get a response from NMS? If not, I'll make that in the form of a motion. We table this until the April meeting for further response from NMS.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
Which will bring us to the last disclosure, which is item 21.72. It comes from the Missouri County Crime Lab in blood alcohol testing, and this came to us in November from the Missouri County Crime Lab Director Derek Sanders reported an incident in the tox section where the lab discovered that an analyst had issued blood alcohol report conclusions outside the lab standard operating 10% threshold and used an average of 4 ethanol results for a reported conclusion where the samples were not within 10% of each other, which was contrary to the lab's procedure. At the time, Derek Sanders is now the current lab director at Brazoria County. That began in October 2021, but he interviewed the analyst concerning the analyst's understanding and application of the procedure. The analyst explained the average for the data set for the calibrators in the batch he worked on was within the 10% threshold. They determined the analyst should have complied with the section in the standard operating procedure that instructs if any of the values of the individual calibrators are outside the 10% requirement, the reprocessed calibrators may be used to determine a specific BAC if the average values of the calibrator for the raw data and the reprocessed data are both within the 10% requirement. The lab concluded the procedure permits the use of reprocessed calibrators to establish the calibration curve, but shows a weakness in the lab's reporting procedures. They went back and looked at 42 cases all the way from 2018 to 2021. They had found in their analysis that the procedure that addressed the blood alcohol analysis, evaluation, reporting is vague at best. It lacked significant clarity. It allowed for multiple interpretations over the years. Interviews with lab personnel identified a tradition of conveying crucial information orally as opposed to in writing. They had no system in place to address whether the procedures are thoroughly understood by personnel. There was also an issue with regard to a spreadsheet used in conjunction with blood alcohol analysis that did not automatically highlight when a sample should be subject to reanalysis. They have since corrected many of these issues. They now thoroughly evaluate the SOP and clarify with all personnel the new guidelines issued. They've implemented a permanent high-quality document control system and are currently have contacted certain bids to facilitate that. They're also discouraging oral communication with staff and require communication to be in written format. And they've also developed a revised spreadsheet highlighting when a sample is selected for reanalysis, which will include a correlation coefficient for the calibrators used. Staff had made a recommendation that we simply table this at this time while we're gathering additional information from laboratory management and while retesting is being completed. Staff sees that some of the issues identified by the new lab director should also be of concern to ANAB, and will work with the director of ANAB to assess potential scope of the issues.
Mr. Daniel, I just, in reading it, some of the issues that Derek has identified since moving over there seem to me to be, I'm not a specialist in the discipline, obviously, but even as a lawyer, they seem to be quite fundamental. I imagine Dr. Kerrigan, Dr. Drake, you probably can weigh in better than me, but I feel like we really need to talk with him about the scope of what he's seeing in all of their analytical methods, their various disciplines, their quality system in general. I don't know if you had anything else, Dr. Kerrigan or Dr. Drake, about that.
Oh, I think it would be good to give the lab director the opportunity to provide some more information.
Well, with that in mind, I would respectfully make a motion to table that and additional information be brought back, hopefully to be available at our April 2022 meeting.
All right, is there a second? All those in favor say aye.
Aye.
Opposed? Motion carries.
Which will bring us to our complaints, or for which there have been 3 since our October 2021 meeting. The first is item 12, is case 21.59. It's brought by Muscat Seed Kadir against the 4th Police Department Serology and DNA section. He's alleged some professional negligence and also misconduct based on untested and unexamined evidence, including some bloody glass fragments, a knife with blood on it, and also a bloody shoe print. He essentially claims that serologists that testified in his trial said there was a way that you could determine the age of blood evidence but failed to conduct any blood time frame analysis. Staff had reviewed the testimony of the serologist from trial. She essentially testified on cross-examination there was no test determining an old blood edge. She did say if blood is wet, you can infer that it might have been recently deposited. And Doctors Bedoli and Coble were gracious enough with their time to review a transcript of the DNA analyst testimony and found it reflected sound scientific principles. Staff had made a recommendation to dismiss the complaint because we don't have authority or jurisdiction to order testing of evidence, and essentially the assertion regarding the testimony on the age determination of blood was really not supported by the trial transcript. Any questions about that particular complaint? If not, I'll make that in the form of a motion to dismiss case number 21.59.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
This next one involves
Yeah.
you. Our next item is 13th item 21.62. It's by Howard Robison Farmer. It's against Southwest Institute of Forensic Science. Is that something you would recuse yourself on, Dr.
I'll
Bernard?
recuse myself on this one.
I'll take this one. Mr. Farmer filed,
Jasmine can then do
good. Had filed a complaint relating to the 2010 death of Janice Wilhelm. The allegation was that Swift determined the manner of death was suicide was incorrect because there was a gunshot residue kit that was supposedly done but results never recorded. The autopsy report indicated gunshot residue kit was released to the Leon County Sheriff's Office. The complaint attached an executed civil subpoena that was been served on the Leon County Sheriff back in 2014 and said something about it must have been lost. Staff had reviewed the matter carefully and made a recommendation to the commission that we consider dismissal of the complaint because it's actually failed to allege professional negligence or professional misconduct related to results of some forensic analysis. Our jurisdiction does not include a portion of an autopsy where a medical examiner or other forensic pathologist is a licensed physician. And the staff confirmed that the gunshot residue kit released by the pathologist to Leon County Sheriff was never submitted for forensic analysis to either Swift or anybody else. So any questions or comments about that item? If not, I would respectfully make a motion to dismiss that complaint.
Do we have any seconds?
Second.
All in favor?
Aye.
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 Motion carries.
Which brings us to our final complaint. It's item 14, item 21.70. It's James Floyd, and it's a matter brought against the UNT Health Science Center. I guess Dr. Bedoli and Dr. Coble might consider recusing themselves on this item.
Yes, we recuse ourselves.
Yes, I'd like to
Yes.
Good. And the complaint was filed by capital murder defendant James Floyd, who was representing himself, and he complained about some fabricated DNA reports by two separate analysts at UNT Health Science Center that, quote, conceal and varnish, end quote, fabricated evidence received from Fort Worth PD. There was no substantive information that actually supported those allegations in the complaint. There have been extensive pretrial hearings on the issue of DNA consumption. The case is a spinoff of the Tricia Crutcher issue in Fort Worth PD. UNT Health Science Center reviewed Floyd's complaint and found the case record really did not support his allegations of fabrication. Staff had made a recommendation to the commission that we dismiss the complaint for failure to allege any facts to support his allegation analysts concealed fabricated evidence. Having reviewed it, I concur with that. And any questions or comments regarding that item? If not, I will make a motion to dismiss that complaint.
Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
And we had, over the last 3 months, 4 matters that were dismissed by staff. It's case number 21.60, 21.61, 21.63, and 21.71. I'm not going to elaborate on the facts. Y'all have those in your materials. Staff has authority to do that. I always think it's better form that we simply bless and approve that. And I'll make that as a motion to dismiss those four complaints.
Is there a second for that?
Second.
All those in favor say aye.
Aye.
Opposed? Okay.
And Dr. Moore, that would include the complaints and disclosures item.
All right, thank you. Very well done. Item number 5 is the discussion as well as a vote on general administrative rulemaking, including rule revisions responsive to the legislative changes to the commission effective September 1st, 2021.
Dr. Bernard, I'm about to turn it over to Lee, but I wanted to say before we left that agenda item that it is really remarkable how many disclosures we're getting from labs, how robust they are. You know, we can always work toward improving the clarity of the documents sometimes, and I think Dr. Kerrigan and I have some thoughts about how we might do that, but it is just great to see how many disclosures are brought forward to the commission and dealt with and thought through before they get to us. So I just wanted to say that because it used to be our agendas were the opposite in terms of we always had, 14 complaints and 2 disclosures. And now it's really the labs understanding their responsibility and bringing things to us. So I just wanted to commend the labs on that.
On number 5, the rule you have in front of you is a general administrative rulemaking that's just responsive to the 87th legislature's changes that were incorporated in that judicial omnibus bill that mentioned the commission, SB 1530. The changes, if you recall, don't necessarily impact our core objectives, but they did provide helpful clarification on the intersection of the Code of Criminal Procedures 3801 and 3835 provisions. And then the main thing that the bill did was to mandate that the commission actually publish a Code of Professional Responsibility, which we already had. So in this rule, the 4 main changes are that we move the Code of Professional Responsibility into its own subchapter. We establish an appeals process for violations of the code, and then we lay out the factors that determine actions for sanctions or code violations. And then we also, in this rule proposal, we consolidate already existing rules for accreditation, inspections, and audits, and then establish an accreditation appeals process there. Does anyone have any questions about the rule proposal or the changes we've made?
To be clear, these rules all go through the governor's office as well, so sometimes they have feedback for us. We've found it to be very helpful because they look at it without the subject matter expertise, so on the point of clarity, it's really great to have their eyes on our rules.
Okay, are there any discussion? All right, is there a motion to adopt the rule revisions that are responsive to the legislative changes that were drafted by the commission staff?
So moved.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Next is item number 6, which is the discussion of the status of the Crime Lab Accreditation Program, as well as nonconformances and reports that were received since October 22nd, 2021 quarterly meeting.
This quarter, the commission has 7 accreditation-related events. There were 4 renewals of accreditation by the commission, 2 continuations of accreditation, and then 1 laboratory that had an extension. The first one that you have listed here in your memorandum are 3 resolved. They're considered resolved nonconformities by Brazoria, but I think we can consider them as part of the inquiry that we're going to have for the self-disclosure with Brazoria County, with the lab manager there. And then also, if you recall, we had questions for Armstrong's responses to some of the nonconformances that were cited as part of their most recent laboratory assessment, particularly in the materials trace section related to paint and fiber. They answered those questions for us, and I think we're planning to have a phone call with them to follow up and make sure we understand what those answers are. And Dr. Busini will probably join in that conversation. Did you want to add anything, Dr.?
Not at this time, yep.
Does anyone have any questions about what's reported here?
All right, no other questions? Then there's no motion needed on that. We'll move to item number 7, which is the advisory committee update.
So for the licensing advisory committee today, we need to consider appointing someone to fill Bill Hines' seat. And the Texas Criminal Defense Lawyers Association has nominated Angelica Cogliano, who attended our licensing meeting yesterday, so we got to meet her then. She's right there.
Stand up. You want to ask her to come forward and introduce herself? She want to say anything? You want to ask her to come forward and introduce herself, say anything? Tell us about
So
it.
I think the fact that she described the licensing advisory committee meeting as awesome means she automatically wins the prize.
She wants to go back to another one? Oh, goodness.
If you don't mind, would you please come up just for a brief second to kind of introduce yourself? Thank you.
Hello, I'm from New York. I can talk loud. I'm Angelica Cogliano. I'm an attorney, and I'm on the board of directors for the Texas Criminal Defense Lawyers Association and the National Association of Criminal Defense Lawyers. I am in my 2nd week of a master's program in forensic science by Arizona State University. I'm trying to specialize my practice in forensic science. I text Lynn an annoying amount of times in the middle of trial when I am confused about things, and I'm really trying to help any way I can in improving forensic science and learning it in Texas.
Well, Dr. Martin, if I can just say a few words. Bill Hines here in Austin served us for the last 4 years in an exemplary manner, and he called me back in the fall, and he's getting called back to trial after trial after trial after the courts think they come out of COVID. Little did they know.
I know the feeling.
Yes, and Angelica is a graduate of Cornell and New York University and Emory School of Law, those places I never could get in, or could you, by the way. And so she brought more energy, enthusiasm to this, and she was unanimous nominee by the Texas Criminal Defense Lawyers Association to do this. She will do great, so we're looking forward to working with her, if this commission will approve her, which I think they will.
Thank you very much. Yeah, oh, and by the way, you're right about one thing. Yeah, you wouldn't get in there.
I wasn't even close. We wasn't even close.
All right. Is there any further discussion? Make a motion?
I'll make that in the form of a motion that we accept Ms. Cogliano as the TCDLA seat and representative on the Texas Forensic Science Commission Licensing Advisory Committee.
Is there a second?
Second?
All those in favor, say aye.
Aye.
Opposed? Well, thank you for your willingness to be involved in this. The pay is great. Thank you. All right, move on to the next part, which is an update on the licenses.
Yeah, just to give a quick update, we currently have 1,309 total licensees. And as you probably know, this is a renewal year for us, so we have about 770 expected renewals. And so Rodney and I are working on preparing for handling those. The bulk of those will happen October, November, and December. And applicants have up to 60 days prior to the date of their expiration to submit the renewal app and all of the components that go with that. So we'll be sending out reminders to the TACLAD and licensees as we approach those expiration dates. They'll get reminders also from the top class program at 90, 60, and I think 30 and 15 days to when they're expiring. So we'll put out more detailed instructions as we get closer to that.
Okay.
Lee, can I ask a question real quick? You said we now have 1,309 licensees. In 2019, we had how many? Approximately?
We were around 12.
1,200? Okay. And then, so we increased 10% or so in the last 3 years.
DPS hired a lot of people at a certain point. So that's a lot of the folks, and then just hires from around different places. But we had a big influx from DPS.
Is there an increase in license in any specific area? A larger increase in areas than others?
DNA.
DNA?
DNA and drugs is, I think, what we, DNA and drugs.
Okay. Thanks.
All right, the last portion of, well, not the last portion, but the next portion is the voluntary licensure regarding forensic anthropologists and document examiners.
Before you is a rule establishing the voluntary license program that we've been trying to establish for about 4 years now, since before the pandemic. And we're beginning with forensic anthropology because some of the requirements are already pretty clear as to what the qualifications and coursework need to be for forensic anthropology. Essentially, the anthropology license is contingent on being certified with the American Board of Forensic Anthropology and complying with and maintaining that certification and the education and coursework requirements that you have to comply with to be certified. And then, of course, you'll have to do the test and then the PT components and do continuing education supplementally to be licensed by the commission. And this is all voluntary, of course. And then for document examination, as you all know, we already licensed document examiners, but we exempted, in 2018, exempted the document examination discipline from accreditation requirements. So now we're just reenacting those rules that were already established as mandatory and making them voluntary.
I just wanted to say one thing about the anthropologists. So this is the first time that we're making a license contingent on an external certification. We had talked about doing that very early on with all the disciplines and decided against it. So I know a lot of you may recall that, and you might want to know, why are we doing it now? So one of the main reasons that we think it's appropriate to do that right now is their board, their body of the association that they are all affiliated with, is right now sort of working through the question of whether the mandatory formal education for being a forensic anthropologist should be a master's degree or a PhD. So they are, and they're doing it with an eye toward actually our licensing program with the thought that it will expand nationally, that other states will adopt something similar. I'm not going to hold my breath on that because we've yet to see it. I mean, people are talking about it, but we'll see. The bottom line is that we brought the anthropologists around the state into a Zoom meeting and talked with them through it, and we ultimately concluded that this was the best approach for them. It doesn't necessarily mean it would be the best approach for other disciplines. Like, we don't do that for document examiners, you'll notice. We'll only do it where we think there is a sound reason to incorporate that certification as a threshold requirement. So for the anthropologists, we thought so. So I thought some of you might be curious about that question, and I'm happy to answer anything. I mean, I feel like the decision not to have done that with the other disciplines was a good decision, and I feel similarly confident that this is the right decision for this particular group of scientists. I hope that makes sense.
The only thing I would add on the voluntary licensure front is that the key difference between voluntary and mandatory is that you don't have to work at an accredited lab. So this voluntary license provides eligibility for anyone who's a forensic practitioner, essentially.
So, I'm all tangled up here. So, when the next time y'all come, we're going to have probably latent print and crime scene. That's going to be a big one. And when that happens, we think we're going to have hundreds of people interested as soon as we open it up. And I think those are going to be some of our folks who are in the labs that we work with regularly, certainly, but also people who are in sheriff's offices and PDs who have been asking for this credential to be made available to them for a really long time. So we're starting off slow, just by virtue of the fact that we don't have tons of anthropologists and document examiners by sheer number. But once the latent print folks are added and the crime scene folks are added and then the digital folks are added, it's going to be, I think, Mr. Daniel, when you ask us for the numbers next time, you're going to see a big increase once we make that program available to people.
Will there be in that a very specific requirement on educational background? Okay.
There will be.
Or training background or?
Yeah. So it's the other reason why we started with document examiners and anthropologists is because there's sort of, I mean, you're debating between a PhD and a master's. It's not a question of four-year degree or not, and if we say one way or the other, it's going to impact, 1,000 latent print examiners. Those are the hard questions to work through. They're hard questions at the OSAC level. There's a lot of debate in these disciplines. The disciplines that we started off with, we had a pretty easy lift because there was already pretty decent consensus what it needed to be. But these are not necessarily true for latent's crime scene, and digital may be different, but certainly latent's and crime scene.
Okay. Any further discussion, Lee?
I think we just need a vote.
Yeah, no, I was just making sure there wasn't anything we wanted to cover. Okay, that said, I'm going to break this up into two motions. One is a motion for the adopt draft rulemaking for voluntary licensure of the forensic anthropologist. Do I have a motion for that?
So moved.
Second?
Second.
All those in favor say aye.
Aye.
Our motion opposed, motion carries. The second part of that is to adopt similar draft rulemaking for voluntary licensure of the forensic document examiners. Do I have a motion?
So moved.
Second? All those in favor say aye. Opposed? Motion carries. Right, and finally is the update on the piloting of the forensic license analyst exam 2.
Yeah, Yeah, I'll just add on the voluntary discussion that yesterday at our licensing meeting, they made the same recommendation that we just voted on. Another thing that we've been working on is distributing materials, study materials for the second iteration of our General Forensic Analyst licensing exam. And we want to pilot this exam on those unaccredited disciplines that will probably seek a voluntary licensure, because we think it's a good opportunity for them to take the test, essentially. So they'll be able to have 4 tries at the test rather than 3 if we can use them as guinea pigs to take the test and gather data so that we can measure whether the test is a good indication that someone's absorbed the material that we're trying to convey. Another thing we did simultaneously is we asked our psychometricians to take the data from the current exam that we have and investigate for us the comparability of the item level and domain level performance of those questions that are on our test. And basically whether the exam is fair across the 3 exams that we offer. If you recall, we have the full 110 question exam, then we have the technician's exam, the modified exam, and then we have what is essentially an add-on exam where a technician takes the 2 components they were missing from the first exam and fulfills those so that they've taken the complete exam. So when we asked our psychometricians whether or not that was fair, the way that we're administering those, all 3 of them at a 70% pass rate, they gave us data on that, and each of the pass rates on those are in the 90s. The General Forensic Analyst Licensing Exam, 98% pass rate. Technician's exam was 93, and then on the 2-component exam, it was 94. Another thing we asked them is whether we could possibly establish domain-level cut scores for our exam. The short answer to that from them was no, because what we would have to do is essentially create separate tests for each domain, which is probably not a feasible option for us. They did give us 2 other options, and the one that the Licensing Advisory Committee landed on yesterday was a modified version of that domain level cutoff, where we have an overall 70% cut rate for all the levels of, for all of the 7 different domains. And then for each individual domain, we have to evaluate the data and look at some of how the questions performed in each of those areas, and establish a different cutoff for each of the different topics. So for example, statistics, since it's generally, if you've looked at this data, is the hardest topic on the exam, obviously. The others, folks perform pretty evenly across the board. So for statistics, we would have to decide how many questions we want the test taker to get right in that area. And it would probably be a lower percentage than the other topics, since it's more difficult. So the Licensing Advisory Committee has that task ahead of them, and yesterday they recommended that we work on incorporating that into the current exam with sufficient notice to laboratories and test takers that are signing up for the test now, probably about a 3-month lead time. Does anybody have any questions about what we've done there? I know there's a lot of data here.
I did have a question. If on the first test, the kind of guinea pig test, if they reach what is considered passing, or they get credit for that one, is that right?
Done the test
Okay.
forever, so it's a bit of
All right.
but we're trying to get them the study materials now. We have them compiled for the most part. We're just missing a couple videos that will give an opportunity for the test taker to see the concepts visually, the same concepts that we have in the written materials. But we're working on getting those out, and I've been in touch with the president of the Texas IAI division, and they are willing to, have graciously offered to help us distribute this information to their practitioners who are going to be those unaccredited disciplines that are going to be interested in taking this. So we'll get a good amount of data from those folks. And by doing that, we can kind of gauge the interest in how many people are going to seek licensure, based on how many people are sign up for this test.
The only thing I would add is that I really do think we're going to get a lot of people to volunteer to pilot. just based on what we're hearing from Texas IAI. And then the only other thing is, originally when we developed the exam and talked about setting the cut rate in collaboration with the psychometricians, we wanted to have a minimum score in each domain, but thought that it was a lot to ask initially. So now that we're looking at it and we have all this data, we can see, if we set it at 70% across domains, what's going to happen to our pass rate? If we set it at 50% across domains, what's going to happen? If we set, we can really see the impact it would likely have and then make decisions accordingly. So I feel, the work of the psychometricians is super valuable to us. I'm so glad we have them to help advise us.
I agree with Lynn, and the reason that first option just isn't viable with an overall 70% cut rate, without the overall 70% cut rate, is that you'll see in the data of that report, the pass rates drop to the 40s in most of the topics. If we were to establish a 50% cut rate, is what I think she poses. Per domain.
Yeah, so if you go to 70% per domain, your pass rate goes way down. Because what we have now is a compensatory model, where if you do really well in one, you don't have to do as well in the other. So what we need to figure out is, okay, well, we don't want people, for example, to not be able to get any right in statistics if they perform really well in the rest of the domains. That's, we think, not the point of administering the test. So we want to hit a minimum level in each domain that's not 70%. It'll probably end up being somewhere in the 50 or 40% range. If that makes sense.
All right. Anything else on that? So the final topic is the discussion about the Institute for Forensic Research Training Innovation Statistics course option.
Yeah, through Sam Houston State University, this course launched the Institute's online option to take statistics. And this course will count towards the component required for licensure in Texas, including for voluntary licensure. I believe for most of those disciplines, we're probably going to require a statistics course, with the exception of a couple of them. And so this is an opportunity, or just a resource that folks can access if they're missing that statistics component. We also hope to add on our website a course by NMS through its associated university there, once we have information about that, so that folks can have a number of options to choose from for stats. Did you want to say anything about that?
Not really, just thanks to Dr. Bazzini. It exists now. We've always had, there are a surprising number of graduates that have undergraduate degrees in science but are lacking the 3 credit hour statistics class, sadly. We've always had made the online stats 3 credit course available to non-degree seeking students that are working in accredited crime labs, but now we have this flexible format course, so it's an on-demand course. It was approved by the Commission some time ago, but now it's actually available. It's a go-at-your-own-pace on-demand course that meets the curriculum requirements. So thank you, Dr. Bazzini, for working with the IFRTI to make that more sort of convenient for working examiners. So in other words, they don't have to enroll in fall, spring, or summer semesters. They can just log on and take the course at their own pace. So thank you.
Very good. All right. Any further discussion on item number 7? All right, we'll move to item number 8, which is to review and adopt a final report from the investigative panel regarding NMS self-disclosure 21.41.
Okay. Okay, hopefully this is working. I have a brief PowerPoint to go over what this report was all about. It's quite technical. This is not working. Maggie points out that it was not on.
Yes.
So, yeah. Okay.
When you've stepped on over into the age bracket when you can't figure out when they're on or not.
Yeah, right.
Clearly they're.
Actually, I've been fumbling around for my glasses a lot lately, too. That's another indicator.
Welcome to the club.
So, you all may recall that the federal government and then various state legislatures legalized hemp. And we had many conversations at the commission meeting about the impact of that on the laboratories that perform forensic analysis in this state. So the legalization of hemp led the DEA first to establish a decision point cutoff threshold for differentiating hemp from marijuana. Other labs around the country and in Texas developed similar cutoff methods. NMS developed one. They used GCMS, and they analyze plants, liquids, and waxes using the method. They had an administrative cutoff of 1% for Delta-9 THC. If you remember, Delta-9 THC is still prohibited in Texas, and it is what, if you go over the 0.3% statutory threshold, then you are in the land of marijuana, which is still illegal in the state of Texas. And many district attorneys' offices around the state still prosecute marijuana cases under the law. So the laboratories knew that, and I think you all might remember back to a meeting where James Miller attended and Chance Klein from Texas DPS, and they told us when hemp was legalized that there's a phenomenon that everyone is aware of that happens in the laboratory where CBD products or something with CBD in it can convert to Delta-9 THC under the processes that are used for testing in the laboratory. It has to do with the heat that is brought to bear in the testing process. And so we knew that this was a phenomenon that could happen. We were told it a long time ago. So I think it's fair to say that people were on the lookout for it, the labs were. And so at NMS, they were qualifying 2 new GCMS instruments for purposes of running this method, one at their DFW location and another out in El Paso. And what they saw was that those 2 instruments were coming back with discrepant results, one being where the result exceeded their administrative threshold of 1% and one where it was lower. So if you think about the implications of that, it means you can run the same sample on one instrument and have a reporting that shows enough Delta-9 THC to exceed the legal limit, and one where it doesn't. Now, many labs, it's very common to actually adopt an administrative cutoff higher than the statutory cutoff of 0.3%, with the idea that that inures to the benefit of the defendant, and they're trying to make sure that they're within, safe range when they're doing their reporting. So what they noticed at first was these samples had large amounts of CBD. So any of Dr. Kerrigan or Dr. Drake, jump in if I'm saying this incorrectly, but I think the larger the amount of CBD, the greater the risk of conversion happening. It's not, can you just... So NMS saw this, they stopped testing right away to figure out what was going on, and at first they, yes?
Just one question, can you go back to the last slide? I just want to clarify what that means.
Sure.
Are you saying 14% of the cases, or there was a 1% and a less than 1%, or it was 14% in one instrument and less than 1% on another instrument?
So what they're saying here is that
their administrative cutoff for saying, yes, this is marijuana, or not, no, it's not, essentially. I mean, the reporting language is different than that, but for layperson, yes, it is, or no, it isn't. Their cutoff is 1%. And they were seeing that in these samples that were coming back with different results on different instruments, that they also happened to have lots of CBD in them, those samples did.
So there's this vast amount of difference between two instruments within the same lab, is what you're saying?
Within NMS's system, right. So you wouldn't want to see that level of
Right.
discrepancy.
So my question is, and maybe Sarah or Jasmine know better than clearly I would, is this the kind of norm that you see in instrumentation that does this kind of work? Or is this unvalidated instruments or not serviced instruments that are given this?
Well, I think in the subsequent root cause analysis that we have from NMS, it's clear that they've changed their validation practices to include validation on the instruments that are used. So the scope of the validation was limited on all of the instruments. It was not a full validation on all of the instruments. So that's why they were seeing differences in the results. So they've changed their validation practices. And also in their subsequent root cause analysis, they've improved their instrument maintenance protocols, because a large part of this artifactual production of delta-9 THC from CBD is related to the frequency with which you perform routine instrument maintenance.
Yeah,
So those were the two factors that really account for the discrepant results that were seen between GCMS instruments within the NMS lab system.
Yeah, because, I mean, if I had an instrument that gave 0.95 and then one that gives 1.1%, I wouldn't be so worried. But to me, going from less than 1 to 14% is a substantial issue.
No,
No.
that's not what it means. The 14%.
Okay, that's what I'm trying to understand.
Yes, the 14% was, relates to the quantity of CBD that was in the exhibits where discrepant results were identified.
Yeah, so it still comes back, one instrument's giving one result and another one in the same lab is giving a substantially, dramatically different.
No, one is over 1% and one is under 1%, but what's common in the samples is they're seeing high amounts of CBD.
That's what I'm getting to, yeah.
Right,
They're reading them in two different values, but they're not consistent necessarily with the true value. But it's a substantial swing between.
the 1% is the delta-9 THC
Yeah.
number, not the CBD number. So it's the delta-9 THC that's the critical thing that they're trying to identify. So one is over 1% delta-9 THC, one is under 1% delta-9 THC. The red flag with that, of course, is that's their cutoff, right? So it matters clearly. So, but what they're noticing that's common in these samples is high levels of CBD, which means, I think, Dr. Drake and Dr. Kerrigan, that the higher the CBD, the greater the risk that you're going to see that conversion
Okay, I got
in
it.
the testing process to delta-9, which is the illegal part. Does that got it? Okay.
Yep.
All right. Did I do okay? Okay, so at first when they came to us, they identified two root causes. One is that they had a massive increase in testing and sample volume, right? So they were doing about 350 requests in 2019 and 6,000 the next year. So they're running a lot of sample on these instruments. And then also, there was a lot more CBD in the products that are coming onto the market once they legalized hemp. You know, I mean, you all know, go anywhere, there's CBD everywhere. You can buy it wherever. And so the people who are marketing the CBD are infusing the products with high amounts. And once they legalized hemp, I mean, that was kind of part of the point of it. So those were two phenomenon that they identified early. Next slide. But when we really looked at it, when Dr. Kerrigan and Dr. Drake and Dr. Busini looked at it, you know, what we saw that's of great value to the labs who are running this method. And what we asked NMS to do was to revise their root cause to place greater emphasis on these two really important factors. One being that injection port maintenance is absolutely critical to the question of whether you're going to see conversion from CBD to delta-9 THC. So they have to be super diligent with cleaning the injection port, or the impact is this conversion issue. And then the second thing is that there's, I think, a lot of times what we see out there in the forensic community, and there have actually been articles written about this saying you do a full validation on one instrument and then you verify in other places. You don't run full validations everywhere. Well, with this method, what they saw, by they I mean HCIFS, HFSC, DPS, and Sam Houston, when they were running that interlaboratory study that Dr. Kerrigan had presented to us a number of times, was just how critical it is with this particular method that there has to be full, independent, rigorous validation each time to make sure that you have tested all your limits properly. So they revised the root cause to emphasize that. They issued a number of corrective and preventative actions, including injecting a 5% CBD conversion control in the beginning of the run after every 10 samples. All of these things are safeguards that they've implemented, adding a reporting limit at 0.15%. And when it's less than that, in non-plant matrices, the result is reported a certain way. They do liquids and waxes. The purpose for changing their reporting language, I think, is to provide greater clarity and to ensure that they're protecting against any of these things that, these phenomenon that they've observed. Next slide. They maintain their instruments more frequently than they were. I mean, I think it's fair to say that they were running a ton of sample. I mean, just super high volume. So that means you have to clean it more often. And then they've made some other adjustments, including adding a 4AP color test, which the DEA does. They provided to us their rationale for why that's helpful. Essentially what that does is, from what I understand, is it alerts you to cases where you really, what I'm gathering is when the color turns a certain way, you know that the delta-9 THC is greater than CBD. So that gives you qualitative information, not quantitative information, but some qualitative information about what it is that you're looking at. Is that a fair description? Okay.
Yes.
Next slide. They're going to transition to a derivatized GCMS method for hemp marijuana analysis. I think this is really significant, from what I'm understanding, because one wouldn't expect to see conversion. Is that correct, Dr. Kerrigan? Switching to that method. So they're also going to be enhancing their validation. So they heard the message about how to improve that process, and they gave us a list of the various things that they'll be doing there. Their experiments will be expanded to include imprecision, accuracy, robustness, carryover studies in addition to comparison data, and they're making changes to the SOP right now. I think they're at the tail end of that. And they're going to discontinue THC identification only and transition all their clients to hemp marijuana differentiation. So that's pretty significant, I think, as well. And I think I already mentioned that we had Drs. Drake, Busini, and Kerrigan working on this. We reviewed documents, went back and forth with NMS to obtain more clarity. There was a lot of document review. It was quite time consuming, so thank you for the panel for all your hard work on that. And then, so the big thing that I wanted to talk about is these recommendations, because they apply to everyone who's running these methods as I mean, there's a lot of work that's being done here. And I did want to point out that at the Academy meeting, for those who are tuning in, James Miller from HFSC is going to be presenting data from the method that was developed and facilitated by Sam Houston in collaboration with HFSC, HCIFS, and Texas DPS. They have data that they're going to be presenting to folks about what they're seeing, where the outliers are, what they think the outliers may be attributable to, and so forth. So everybody should read the document that Dr. Kerrigan put together back in September 2020. I know that Dr. Stout sent that out to the TACLAD, but it is a sort of a sample protocol, and it's helpful to read that because it's instructive, certainly for the labs who are running these methods. And then again, emphasizing the need for rigorous validation, especially with this method at each site where it's being run. And then when we refer to robust quality assurance practices, we're talking about things like injection port maintenance, the selection of the liner. I know at one point was a very significant factor in tracing down why these things may be happening, including a CBD control for risk mitigation. It's highly, highly recommended. It really helps to mitigate risk, to red flag things that might not otherwise be observed. And then analysts may need additional training because this is different than perhaps other seized drug methods that they've run in the past. The SOP has to be developed based on method performance in the lab where the method is being run. And one of the things that had been pointed out early on is that there are a lot of similarities between this method and what has been done for quite some time in the toxicology discipline. So it might be helpful for labs to bring in their toxicology colleagues to help. So did I cover everything? Dr. Kerrigan, Dr. Drake, Dr. Busini, anybody have any questions?
It's a pretty substantial unintended consequence from an original bill that was initiated to help the agricultural group. I don't think anybody expected this much. Yeah. Well, that's because you're just out there, Peter.
In fairness to the laboratories, they really tried to convey a lot of the consequences, but there are competing interests.
Yeah. Well, it's a far different cry from the original time that we heard that if it dried out, you got an increased amount in the plant material, and then as you expand it on, it's a lot more complicated than just a simple analysis, for sure.
It's quite complex. It really is. And this, again, this was quite a technical review that we did and report. I mean, easy for the chemists, but for the lawyers, we worked hard to get it right. And I do want to commend NMS for bringing this to us, because these are the conversations that all the labs running this method need to be having. They need to be reading this report and learning from what NMS raised to ensure, because, we help facilitate that interlaboratory validation study, but we're not in the labs checking to see whether they are doing proper injection port maintenance, whether they are running validations that are sufficiently robust, and so on. So we're putting these resources out there with the expectation that the laboratories are going to read this and reflect on it and make any changes or adjustments internally that might need to be made.
Yeah, well, thank you to all the laboratories and all the individuals that participate in this, because otherwise it gets discovered later on and then it becomes an enormous issue. So it's a good thing, and thank you to NMS and to our staff for putting this together. Any further discussion? Okay, we should move on unless there's anything further. Oh, we need to adopt the final report.
Make
So I
a
need a motion to adopt this report.
I'll make
Motion
the
to adopt final
motion.
report from investigative panel regarding NMS self-disclosure 21.41.
Is there a second?
Second?
All those in favor say aye.
Aye.
Opposed? Motion carries. Now we'll move on to agenda item number 9, which is an update from the investigative panel regarding complaint 20.55 Expertox.
So I mentioned this earlier. We retain the services of Dr. Tim Rohrig, who is a forensic toxicologist. He gave us a very thorough report on his observations with respect to the issues brought to our attention by the District Attorney's Office in Philadelphia regarding Expertox's hair analysis. We have provided all of this to CAP, which is their accrediting body. They are conducting an investigation. We are awaiting the results from CAP, which we expect to have probably within 30 to 60 days, and then we will update the commission on next steps. We want to give the accrediting body the opportunity to weigh in on this.
Any discussion on that? So we will move forward to item number 10, which is to review and adopt the final report from the investigative panel regarding complaint 21.32, which was the Harris County Public Defender's Office for Theodore Schmidt.
I'm not sure if it's working. Try it. See if it works. Just say next slide.
This was a complaint filed by the Harris County Public Defender's Office on behalf of a capital murder defendant named Timothy Schmidt. It alleges that Dr. Melba Ketchum, who was the director of DNA diagnostics, committed professional misconduct when she testified to the results of canine DNA analysis at a trial for two reasons. Number one, the laboratory was not accredited when she did the analysis and offered the testimony. And number two, she failed to estimate the frequency of the DNA sequence obtained from the reference and question samples, and therefore gave incomplete and misleading testimony. Next slide. Just to elaborate on that, Dr. Ketchum testified in this defendant's trial in July of 2010. The complaint alleges that she testified that hair found on the defendant's clothing matched, quote unquote, hair from the victim's dog. She testified at that trial that her lab was not accredited, and the complaint alleges that this is misconduct for her to testify about this type of analysis while knowing that her lab was not accredited. With regard to the frequency of the sequence observed, the complaint alleges that she testified regarding mitochondrial haplotyping sequences she found in the victim's dog sample, and that it was identical to the sequences found from hair on the defendant's clothes. And she provided no statement regarding the estimated frequency of those sequences in a canine population, and therefore failed to explain the limitations of her opinion. The complaint attached a letter opinion from UC Davis Director of Veterinary Genetics, a lady named Christina Lindquist, detailing the history of accreditation in the field of non-human DNA analysis. The first lab accredited was the U.S. Fish and Wildlife Forensic Laboratory in 1997. Once they became accredited, they initiated an in-house proficiency testing program. And then in 2004, the USFWL made this proficiency testing program available to other laboratories. Also, this letter opinion from Ms. Lindquist asserts that all mitochondrial haplotype conclusions must have an accompanying statement regarding the rarity of the haplotype observed to avoid misleading the trier of fact. These sequences cannot be used to individualize a particular dog as having contributed a sample, and some of the more common haplotypes can be present in up to 1 in 6 dogs. As part of the investigation, we interviewed Ms. Lindquist, and she confirmed all these with additional details that are in the report. Just quickly on the criminal case, Mr. Schmidt was convicted of capital murder. It was a circumstantial evidence case. The victim's body was found in a ditch with their hands bound with duct tape and duct tape around her eyes, gunshot wound to the head. Police found the victim's car in a parking lot where she had been shopping the day before she was murdered, and review of store video captured both the victim and the defendant in the store and then going off into the parking lot out of camera range. And in this store video, the defendant was wearing certain clothes. And so they obtained a search warrant for those clothes, and they were found, clothing similar to that was found in the defendant's garage, and suspected dog hair was found on a jacket and a shirt seized from the defendant's home. So, quick summary of Dr. Ketchum's testimony in the case. She testified that her lab was not accredited when the DNA analysis was performed in this case because there was no provider of animal proficiency testing, which is a component to obtain accreditation. Her testimony in the trial was that the hair from the victim's clothing and the victim's dog had the identical mitochondrial sequence as hair recovered from the defendant's clothing. And she testified that she chose not to provide statistics relating to this conclusion because there can be a small amount of variance between databases depending on the geography and the breed of the dog, and that without using a database that's local to the community, she doesn't provide statistics related to the frequency of the DNA sequence in that population. ANAB provided us a history of accreditation as part of the investigation, accreditation for non-human DNA analysis. Texas Parks and Wildlife was accredited in non-human DNA in 2006. The National Fish and Wildlife Laboratory was accredited in non-human DNA in 2007. And UC Davis obtained accreditation in non-human DNA in July of 2010, which happened to be the same month that Mr. Schmidt's trial was conducted. We interviewed Dr. Ketchum as part of the investigation. The laboratory no longer exists. She no longer practices in this field. She was unable to produce the case records for a variety of reasons, the passage of time, a lot of storage issues, some flooding and other natural disasters that she had been put through. She told us that her lab began conducting forensic analysis in 1995 and performed both traditional STR and mitochondrial DNA testing. She explained that she tried to achieve accreditation but was unable to do so because she couldn't obtain the required proficiency testing in non-human DNA analysis. The analysts in her lab participated in external human DNA proficiency testing but not animal, and she was unable to ever secure these proficiency tests from the U.S. Fish and Wildlife Laboratory. She knew at the time of her testimony that accreditation was required under Texas law, but just believed it was unattainable for a small private lab like hers. With regard to the sequencing issue, she testified that she was in the process of developing a local database at her lab, but she didn't feel comfortable using what she had because it was insufficiently robust. She acknowledged that there are published published databases available that contain far more data, but she declined to use them, citing her concern that canine population variations occur from region to region. She advised the prosecutor that the recommended course of action would be to test some local dogs and develop a local database for the purpose of providing a quantitative statement, but the prosecutor did not want to pursue that data collection. And so she decided to testify without offering any statistical significance regarding the observations. At the close of her interview, she did apologize for any possible unclear and inadequate testimony she gave that didn't express the limitations of her findings. She did not intend to mislead the trier of fact when she testified that the DNA sequences were identical, but in retrospect could see how that could mislead a lay jury. So observations and findings in this report regarding accreditation is Dr. Ketchum's laboratory was not accredited by any recognized accrediting body at the time of the analysis or the testimony. That's the subject of this complaint. Forensic biology DNA is a forensic discipline subject to the accreditation authority of the commission, and nothing exempts non-human DNA testing from that requirement. There's a provision in the Code of Criminal Procedure that prohibits forensic analysis from being admitted in criminal cases if the crime lab is not properly accredited, but this is a rule of admissibility. It's for a trial judge to enforce, not the commission. So with regard to a determination regarding professional misconduct or professional negligence, in the accreditation question, the commission finds in this report that she was under the mistaken belief that her laboratory could not achieve accreditation as a practical matter due to the lack of available proficiency testing, but her assumptions are not supported by information provided by TACLAD lab. The report concludes that there's insufficient evidence to conclude her laboratory's inability to obtain accreditation during the time period in question constituted professional misconduct, a deliberate deviation from the standard practice that an ordinary analyst would employ. But we did receive unequivocal information from the accrediting bodies that accreditation in non-human DNA was obtainable and available, and whatever efforts that she did make to participate in that U.S. Fish and Wildlife Laboratory proficiency program fell short, and the report concludes that Ketchum was professionally negligent in failing to achieve accreditation for the laboratory before performing this analysis or offering this testimony. With regard to her testimony about the I'm sorry, I lost my page. With regard to her testimony about the outcome of her DNA analysis, her testimony expanded quite a bit from her written report. This is the observation that we saw. Her written report indicated that the evidentiary samples could not be excluded as having originated from this known dog of the victim. But at trial, she testified that the sequences obtained from the evidentiary items were identical to the reference samples without providing any limitation regarding the outcome of the comparison. Dr. Ketchum co-authored a paper in 2005 that addressed recommendations for non-human DNA testing, and part of that paper addressed specifically the need for qualitative and quantitative statements in the context of non-human DNA forensics. We set it out in the report, but this paper provided that when interpreting forensic evidence, a quantitative statement about the outcome of the analysis should be provided. And when a comparison of the DNA profiles derived from an unknown and reference sample fails to exclude an individual as a contributor of the evidence sample, a statistical assessment or probabilistic reasoning are used to convey the significance of the finding. As I stated, the case records are no longer available, and we're unable to determine the quality of the data at this point. We do believe, though, that regardless of whatever that data was, a fact finder, the jury, could easily be misled to believe that an identical DNA sequence means essentially the same thing as an identification. And she should have been concerned about testifying without this quantitative statement. The commission in this report would find that the testimony of Ketchum in the trial was incomplete and posed a substantial risk of misleading the trier of fact. And we conclude here that Ketchum was aware of and consciously disregarded the accepted standard of practice as set forth in the peer review article she co-authored in 2005, concluding that her testimony constituted professional misconduct because she was aware of and consciously disregarded an accepted standard of practice in failing to provide a quantitative statement about the outcome of her analysis.
Thank you. That was well written and presented. We have any discussion on this?
One thing that wasn't mentioned is that Drs. Badoli, Coble, and Mr. Daniel were all on this panel.
It was a brilliant paper at that, you know.
And Dr. Badoli was also a co-author on that paper, but we obtained waivers from Harris County and from Dr. Ketchum that he could still participate in this despite having been a co-author. And I mean, I'm happy to answer any questions, but, you know, Dr. Ketchum did recognize that it could, you know, in retrospect, could be problematic, her testimony. And so one of the things that we say in here is that, you know, accredited labs, if they see something in testimony that's brought to their attention, they'll make a correction. You know, they'll let stakeholders know this is something that we didn't intend to say this way, we made a mistake of fact, or it just didn't come out the way that we intended it to, and they'll correct. So we suggested that she consider doing the same thing in collaboration, of course, with the legal stakeholders involved. So we'll see what happens from here. But the rest of it is out of our hands now.
All right. Are there any further discussion? If not, I need a motion to accept the final draft, final report draft. Adopt. Adapt it. Do I have a motion?
So moved.
Second?
Second.
All those in favor say aye.
Aye.
Opposed? Okay, report's accepted and passed. Next is item number 11, which is an update on the investigative panel regarding complaint 21.27, the National Innocence Project on behalf of, I guess, Nanon Williams.
Yes. So we don't actually have any significant update. We did meet as a panel, and we'll be focusing on obtaining subject matter expertise to help guide us through this, because it's going to be a fairly significant project for us. But since we had, you know, we're sort of handled the first 3 reports that you had in front of you today, and now we'll shift and we'll have a more substantive update at our next meeting.
All right. So next is item number 12, which is an update from the investigative panel regarding complaint 21.46, Damon Earl Lewis.
So we did meet as a panel to talk about how we're going to proceed with respect to this, and I think We have some writing to do. My hope is that we will have a draft for you at the April meeting. A lot of sort of the point of the work that we're doing is to try to highlight issues that hopefully will be attended to, at least in part, by the new OSAC subcommittee on forensic nursing. So we do have some writing to do, and we'll have more to present next time. Dr. Downing, I don't know if there's anything else that you wanted to add to that.
Nope. We can discuss that, but I am happy to report that I am a member of that new OSAC forensic nursing subcommittee. Thanks in part to Dr. Kerrigan recommending I apply for that, and I will be serving as vice chair. So hopefully there'll be some nice connections made.
All right, then we'll move to the next, which is item number 13, which is to review and adopt the final report from the investigative panel regarding self-disclosure 21.49, Fort Worth Police Department.
Goodness. Oh, goodness. Yeah.
Okay, since our clicker seems to have decided to stop, you can just follow along, right? Help me out with this. Okay. So you might recall that Fort Worth Police Department Crime Lab came to us with two different disclosures related to the application and hiring process for a DNA analyst who's licensed. Her name is Andrea Morrison. She's employed and currently in training to be a DNA analyst at the Fort Worth PD Crime Lab. So we accepted the investigation, in part because there were some pretty significant inconsistencies from the first disclosure to the second. So we accepted it to determine whether she provided false information on her application for employment. That was a City of Fort Worth employment application, to determine when the laboratory management knew that this had occurred, and to assess their response to a possible false entry on the employment application. So here's the question that was asked. Have you successfully completed college coursework in all of the following areas: genetics, biochemistry, molecular biology, and statistics or population genetics? And then there was an indication that transcripts would need to be provided if the individual was selected for an interview. So the transcripts didn't go in immediately. They were requested after. And the analyst answered this question, yes. So there was a hiring committee that looked at applications for the DNA analyst positions. They had actually two people that they hired in that time frame, and it was the lab manager, the TL for the biology unit, and the former CODIS administrator, who since has moved to the Tarrant County ME's office. First, the analyst was interviewed by telephone. This was during certainly high COVID times, so ordinarily there would be an interview not in person first and then one in person, but for this it was, the first one was by phone, the second was by video. So two of the panel members attended the first meeting, all three of them attended the second meeting. In both of those meetings she said she did not have molecular biology, and she was offered a position on the condition that she complete that course within a specified time frame. So then on August 6th, an assistant district attorney with the Tarrant County Criminal DA's office came to the lab, in part because of recommendations we made in the complaint the report that came out of the complaint that Teresa Crutcher filed. The ADA's name is Dan Monty. He came to the lab and he gave a presentation talking about Brady and Michael Martin Act disclosures. And he talked about examples of the types of things that would be subject to legal disclosure. And one of the examples he used was a false statement on an employment application. Coincidentally, he brought that up. And that caused the
TL for the biology section to realize there might be an issue with the analyst's application. And the reason she thought of that was a few weeks earlier, she had heard, and she doesn't recall whether it was the statement was made directly to her or she heard it in passing, but the analyst made an offhand remark that she had to answer the question about her coursework, yes, even though she didn't have molecular biology, in order to make it through the HR screening process without being screened out. So the biology unit supervisor, Cassie Johnson, as she was sitting there listening to Dan give the talk and use that example, it occurred to her, I think I just heard the analyst say that's what she did a few weeks ago. So she went and said, you know, we need to talk about something. So Mr. Monty, Mike Ward, who's the lab director, Phil Aviles, who's the quality manager, and Cassie Johnson all met to talk about it briefly. You can go to the next slide. And during that conversation, Ms. Johnson, the biology unit supervisor, posed the question to Mr. Monty in the form of a hypothetical. And Mr. Monty said, I'm not really interested, I can't respond to hypotheticals, you need to investigate the facts and provide that to our office so that we can determine what disclosure needs to be made. So they said about investigating it. The request was put to the quality manager that he begin investigating. So he started by interviewing the analyst. And he interviewed her with a prepared set of questions. They had a witness there. His name is Pat Wertheim. He is a latent print analyst, long-serving latent print analyst in the lab, who has come in. You may remember he also appeared in the Teresa Crutcher investigation. He often comes to serve as a witness, and he will write up these things called memorandum of record. He writes a memorandum of record noting his observations during whatever meeting it is. So we have two of those for two separate meetings that happen, one of which is the one that's on this slide. And so the quality manager then submitted a disclosure to us. He didn't show the disclosure to anyone else in the lab before he sent it, which is, I would say, not typical. But the disclosure said two things. One is she didn't have the molecular biology course, and the second is that the management, the hiring panel, knew she answered the question falsely before they hired her. So of course that was a red flag to us, as it would be to the DA's office and any other stakeholders. So that was the first disclosure. So the lab manager and the biology unit supervisor didn't know this disclosure came to us, or to the DA's office, or to ANAB. And once they learned of that and they read it, they said, wait a minute, this has inaccurate information. We didn't know that she lied on her application. We knew she didn't have the molecular biology. We proceeded knowing that she would have enough time to successfully take the course while she was in training, but we didn't know that she provided false information. So they held a meeting in person that had the analyst, Ms. Morrison, the lab director, the biology unit supervisor, the quality manager, and Mr. Wertheim at it. And there was a discussion of numerous things, trying to clarify who understood what when, and also they talked fairly extensively about HR's role in screening the applications and the fact that management relied on HR to screen them. Now, there's some discrepancy about whether they also said that HR had screened the transcripts. But regardless, the second disclosure we got put heavy reliance on the idea that HR had vetted these transcripts. During that meeting, the quality manager was reluctant to change the first disclosure that came to us because he believed the facts were correct. He believed that the results of his investigation with Ms. Morrison was that she said she made it clear to them that she answered the question incorrectly in order to make it pass to HR screening. So there was a lot of heated debate about that, and at a certain point, the lab manager said, well, if you don't change this to correct the facts, I'm going to have to take it up to the chain of command. So there was a lot of tension, and definitely not an ideal collaborative working situation during the course of that. Next slide. So then we got this second disclosure, which you all had last time, which basically corrects the misimpression that management knew she provided a false statement on her application. They being the manager of the lab and the biology unit supervisor, they didn't see the second disclosure before it was submitted either. The contents raise some real questions about whether during that September meeting there wasn't some attempt at shifting blame for vetting the application to HR. I think most of us any sort of time you spend around crime labs, if there's one thing you realize, they don't rely on HR for much of anything when it comes to assessing whether they have people with the appropriate university level coursework, because HR doesn't have the subject matter expertise to be able to look at it, even if they had the transcript, to be able to look at it and really understand whether the course description is what it is that, for example, the QAS actually requires. Next slide. So we made a series of observations in this report. One goes back to sort of the very recent history in the biology unit at Fort Worth PD. You all might recall back in 2019, which is not that long ago. I mean, it feels like a decade ago, but it's just a couple of years. A DNA analyst resigned due to professional misconduct that the lab brought to our attention. And in that case, this analyst had said she ran a performance check that was required to be run. She didn't actually run it. And instead of just saying, I forgot to run it, she made up data, then she pulled a plate that hadn't been used and tried to pass it off as having been thrown in a trash receptacle that the unit supervisor had already looked through, and it magically appeared, a day or two later. So that was certainly an incident of professional misconduct, and she resigned from the lab and resigned her license. Then we had the complaint filed by Teresa Crutcher that I know you're all familiar with. Well, the biology unit experienced a series of departures. 3 of their analysts left. Then Teresa Crutcher was fired. So then we were left with only 1 qualified DNA analyst in the biology unit, which is the supervisor of the unit, Cassie Johnson. And so ANAB limited the scope of the work that could be done in the biology unit due to the fact that they didn't have sufficient staff to comply with NDIS rules. And the analyst who is the subject of these disclosures was an attractive candidate because she already had screening experience for forensic biology, so that's going to cut down the training time by at least a bit in order to expedite getting to independent casework. Next slide. So the findings that we have are that the analyst knowingly submitted a false entry on her employment application, a City of Fort Worth government document. Management was unaware that she had submitted that false entry when they offered her the job. So we made that finding based on many interviews, reviewing all of the documents, the contemporary memoranda that Wertheim drafted. We really do think that they weren't aware because they didn't have the applications in front of them. They had the CVs in front of them, but no job applications printed out. There's no doubt that there is a deeply concerning high level of risk right now based on the relationship between the quality division and the laboratory manager. We have 2 disclosures coming to us without review by other people in the lab. We understand that that was in reliance on a comment we made in our last report saying that the independence of the quality manager needs to be sacrosanct, but that was to say, that was in response to the lab manager in the last complaint having written an entire nonconformance report without the quality manager being involved at all. He just took that role over. And so we said that's not the way it's supposed to work. But independence in a healthy functioning laboratory doesn't mean that the quality manager sits in her office, does everything without talking to anybody. You can't be effective if you aren't communicating with the people who witnessed the events, whether they be technical issues or personnel issues. So the dysfunctional dynamic, I think, is a major area of risk for the lab. Next slide. We issued a finding of professional misconduct against Andrea Morrison, who is a licensed DNA analyst. So just to refresh your recollection, professional misconduct means the forensic analyst, through a material act or omission, deliberately failed to follow a standard of practice that an ordinary forensic analyst would have followed, and the act or omission would substantially affect the results of a forensic analysis. We want to remind you all that would substantially affect the integrity of the results of a forensic analysis includes acts that call into question the integrity of the analysis, the analyst, or the lab as a whole. It doesn't necessarily mean that you issued a report in error or findings that were wrong. It's broader than that, and it always has been, and that's reflected in our administrative rules. Next slide. The deliberate act of answering with incorrect information in order to get past the HR screening process goes to the question of integrity. Commissioner Parsons, who's not here, asked a question about whether she would do anything differently in hindsight, and she said, I would prefer to answer properly on my application. However, the outcome would have been different. So at this point, I would say no, because I do enjoy having a job and doing the job I have. So even when asked, when given the opportunity to say if I were to do it over again, I wouldn't provide incorrect information on a city job application, she did not take that opportunity. So in our minds, that demonstrates a fundamental lack of understanding of the principles that are in the Code of Professional Responsibility. Next slide. Which state that a forensic analyst shall accurately represent his or her education, training, experience in areas of expertise, and they're supposed to come forward and notify management or quality assurance personnel of breaches of ethical, legal, scientific standards or questionable conduct. So not just I don't have the molecular biology, but also I provided an incorrect answer on my application, certified that I did. One would expect her to have regretted doing that upon reflection, but it does not appear that she did. So we have a finding of professional misconduct against her for that. Next slide. We also have a finding of professional negligence by the management of Fort Worth Police Department Crime Lab. You can see the definition is very similar to misconduct, except it goes to whether the laboratory should have been aware of an accepted standard of practice. It also does not require an adverse outcome on a criminal case or report. Next slide. So in August of 2021, the management and the unit supervisor became aware that she knowingly submitted a false answer on her employment application. Actually, Johnson did in July, but the comment didn't really register with her until Dan Monty came and gave his talk on legal disclosure, Brady and Michael Morton. She continues to be employed as a DNA analyst as we sit here. Both the lab manager and the unit supervisor told the panel that they would not have hired the analyst if they had known that she lied on her application when they interviewed her. Commissioner Parsons asked if they had concerns now, if it was still a red flag now, and both said it was less of a concern because they haven't seen anything to indicate any problems since she's been there. She's hardworking and gets along with others. And they just said this is just going to be a mistake that she'll have to face when she testifies, but we're not worried about her. We don't see any reason to believe that there will be issues because she's been here and we don't see any red flags. Next slide. One of the things that was troubling was that the lab manager stated his understanding this was based on conversations that the quality manager had with the DA's office, that they would not exclude her as a witness, and that it wasn't going to be an issue. And we don't think that's the position of the Tarrant County criminal DA's office at all. That is not the sense that we get. They don't have a do not sponsor list because anyone in the chain of custody may need to testify. But that should not be interpreted as them not having concerns and everything's fine. I don't think they would take that position at all. But what's disturbing, I think, about it is that, you know, most of our lab managers have ongoing existing relationships with the district attorneys, either across the state in DPS's case or in the jurisdictions that they serve. So it's odd to me that one would accept sort of these hearsay conversations that happen without ascertaining firsthand the impact of something like this. You know, they seem to see it as a mistake, but we see it as more than that. Next slide. And one of the reasons we see it as more than that is that they had an analyst who made up the existence of a plate that she didn't run in order to keep her job. So the question, I think, that Commissioner Parsons, who's not here today, but if he were, one of the questions he posed was if she would, you know, provide false information to get the job, why wouldn't she provide false information to keep the job, as we saw in the Schaffner example. And then, you know, the reasons that were given for firing Teresa Crutcher were that the DA's office had concerns about sponsoring her, that it would be problematic. And so we're not really sure where the breakdown is, that if that's the reason she was let go, why that doesn't apply here. Obviously, that's for the city and the DA's office to work out, but it just seems like a lot of inconsistencies in the way things are being approached. Also, the fact that, you know, the capacity to be honest is really not measured by whether somebody's hardworking or they get along with others. We had an example a long time ago, Dr. Kerrigan will remember, years ago now, of a drug chemist in DPS's Houston lab. And one of the things that was mentioned to us in those, and this is an example that is well laid out. It's in Ex Parte Cody, which is a CCA opinion written by Judge Hervey. You know, this analyst had issues with an analysis of an alprazolam tablet. He was struggling with it, and so he took evidence from a different alprazolam case to support his findings in the case that he was working on, that he was struggling with. But one of the things that we observed in talking with the analyst was that he was very easy to get along with. He did all the jobs that nobody else wanted to do. He was a really likable guy. He just didn't, he was not suited for that job. And when faced with a tough situation, after having had tech reviews flagged multiple times, he made a really, really poor judgment call. But if you were to measure whether he was going to lie by how likable he was or how hardworking he was, I don't think that would be a fair gauge to use. Next slide. We already talked about this. So we have a finding in there that Fort Worth PD Crime Lab Management was professionally negligent due to their failure to take sufficient corrective action, I would say. It is tragic, we agree, for a junior analyst to face extreme consequences, but this work is serious. People's lives are at stake. People's freedom is at stake. And so we need, I think, people in the crime lab system need to take serious action when we have honesty and integrity questions. So that's it. Any questions?
I was just wondering, maybe clarify on one point, it was in your report, that maybe helps with the culpability here. You'd said that the other people that applied for the job, but they didn't have the requisite education and they didn't make it past that first step. Wouldn't that be a flag for the management if someone says, I don't have it subsequently?
So our understanding,
something wrong with the-
right, we looked at the email. We received some internal email traffic, and there were notations, and Robert knows the documents a little better than I do, but there were certainly notations that said, this person doesn't have the coursework. You know, they answered the question honestly, and they were screened out. So the fear of being screened out was because she probably would have been screened out. I mean, that others were. There were examples of other folks who were.
No, my observation is if you screened out people that didn't have the coursework, and then after you've got a person either interviewing them or whatever and says, I don't have the coursework, that should be a flag that something's wrong in the system.
I see what you mean.
Yeah.
So their response to that is, we didn't really put two and two together on that question because we didn't have the applications in front of us. We just had the CVs and we didn't remember. So that question that I showed, the very first slide, that's a question they sent to HR. They drafted that question. Now, it's a number of years ago that they did that, but they had just, I think, probably forgotten that there's a question on there that says, do you have all the following? Yes or no? So yes, I mean, some people, that might have been a flag, like Mr. Daniels, Mr. Daniel, when we interview people for the commission, he always asks us for applications. And my tendency is to focus on the CV. But there's a good reason why he asks for the application, because he wants to see how they answer the questions. So whenever he's been on, interview panels with us, we look at it all. And part of it is because you look at it and you say, oh, well, wait a minute. How are they answering these questions, So I think they just forgot what was on the HR application. And because they were so focused on the CV, and then they got focused on, well, can we hire her without molecular bio and let her take it in the course of the next year and a half or 2 years that it's going to take us to train her? And she took it and she passed it. She took it at Berkeley, University of California, Berkeley, online. So she was able to do that successfully. So that part of it, I think some labs will hire people contingent on finishing certain things. So I'm not sure that part is completely uncommon.
No, I'm not opposed to that part. I'm
Yeah.
just more about if you're screening people for requirements and then you won't entertain them, yet then afterward you have somebody who discloses they didn't have the requirement, that to me should have been a flag. That's
It wasn't. It wasn't a flag. It wasn't their practice to review the applications, it generally speaking. And we asked them that, and they said the reason they would go to an application would be primarily to see in the salary section, where they ask you, like, what's your current salary, so that they could see whether what they would make in the form of an offer would fit within the budget. And that's really the reason they would turn to the application, but not for any more in-depth review than that.
Thank you.
Any other discussion? Then do I have a motion to adopt the final report draft?
I move.
Do I have a second? Second. All those in favor, say aye.
Aye.
Opposed? Motion carries. I'd like to thank everyone that was involved in the investigation of this. It was a lot of hard work on this particular item. Next, next is item number 14, which is an update from the investigative panel regarding number 21.45, James Smiley.
We don't that will be in your materials for April. We really don't have much for you today on that.
Okay. All right, then we'll move next to item number 15, which is discussion of the commission's statement regarding alternate firearms opinion terminology.
So I'm going to stand up for this one and clutch the podium a little bit. So the FBI has a general counsel department like a lot of laboratories now do, and an assistant general counsel who's in charge of training forensic analysts across the FBI sent out a 2 or 3 page memorandum or document that was sent to members of AFTI across the country, including some of our folks here in Texas who are members. And essentially it tells firearms examiners that if they are prepared to make an identification statement based on their analysis, such as this is the gun that fired the bullets recovered from autopsy or something similar, if they're prepared to make that statement, but a judge says that they, in listening after an evidentiary hearing to the data that are presented and the arguments presented by counsel, if a judge says, I don't believe that individual identification, such as this is the gun type statements, I don't believe that's supported, but I'm going to allow you to testify, but limit your testimony to sort of a lesser included statement. So something like, the weapon cannot be excluded as having fired the projectiles, or it could have fired them, or those types of statements that are often used in forensic science. If that type of a limiting statement is requested of you, forensic firearms examiner, you should say that doing that would be committing perjury. And so it's basically take my full statement of identification or I would be committing perjury, and you should put that on the record essentially to put the court on notice for the appellate process. And so we received this and were pretty struck by how incorrect it is on the law, how misguided it is in terms of putting our scientists in a really bad position, and how it really, I think, would adversely affect their credibility in the criminal justice system to follow any of the things that are in that document. So we created a statement that describes the commission's perspective on this that I had sent to everyone. And Judge Hervey was involved in that. The director of Texas DPS, Steve McCraw, a number of prosecutors, defense lawyers around the state, and our forensic labs. Thank you to DPS, HFSC, everyone who weighed in. But this was sort of the consensus statement that came out. And we feel very strongly about it. And if anyone has any questions, I'm happy to answer them. But we have gotten positive feedback from various places who were equally as disturbed by this thing that got blasted out to all of AFTI. I don't think it's an official statement of the FBI because it's not on FBI letterhead, but it was sent from a very high-ranking person within the general counsel's office from his FBI email. And it was sent out saying, distribute this as you see fit, and went to all of our people here. So, questions, comments?
Did we have anything back from AFTI on the statement?
Nothing official. I know our members who are here in Texas understood why it was problematic. I know that some of the counsel for labs across the country, the other general counsels, they have an association, they meet, and I know a lot of them were grateful that we put
this statement together because it gave them something to give out to their people to redirect them where they need to be directed. Whereas before, you know, if the general counsel, him or herself of the lab, said you really shouldn't listen to what the FBI is saying here, they would say, well, why not? He's the, you know, it's the FBI and he's in the general counsel's office. So this was helpful, I think, to some of them in articulating why it's really a problem. And what's striking to me is it contradicts the alters, which is that those are their own guidance that they adopted to guide them in how they proceed with testimony. So I'm not really sure what's going on here, but we wanted, since it got blasted so broadly, and we thought we needed to say something.
Anything else? Thank you very much. The next is item number 16, which is a discussion from the Houston Forensic Science Center Latent Print Section's procedure for judgment and sentencing. Clearly, Dr. Stout, you wrote this. With regard to phase comparisons performed once a finding of guilt has been established.
Is that a commentary if I use a lot of words?
Remember the word succinct.
Yes, I will try to be succinct here because I know latent prints is kind of on the edge of stuff. So,
It's not working.
it's not working. Next slide. I know probably some of the lawyers are familiar with this, but so everybody is aware. Latent prints get used as in a variety of places in the trial process. And at sentencing, and this is where this has come up, prior convictions play a role in sentencing and the severity of sentencing. There is an evidentiary standard for proving those priors belong to that defendant. That's a reasonable doubt kind of standard. And what is classically done with this, it can't be just simply the name, but there are latent prints associated with past records, both what are called jail cards as well as what are called pin packs. And so this is typically done by latent prints to prove this up. How this happens around the state predominantly is sheriff's offices are where this happens because they are the custodian of records of the jail cards. But what happens is the latent print person, I think I hesitate to call him examiner necessarily, goes, rolls the prints of the defendant at the sentencing hearing, then looks at those jail cards and pin packs with those rolled prints, typically sitting there on the stand or at a table in the back of the room, and then testifies that that is the individual that those records belong to. The exam on the stand kind of thing. Now, we got drawn into this because there's an enormous, basically catastrophic backlog in the courts. The sheriff's office is way beyond capacity. They were attempting to find ways to deal with this, so it came to us to try and deal with some of these JNS cases for HPD, which actually make up most of the cases moving through Harris County courts. Next slide, please. Here's a few examples of what shows up in those jail cards. So part of the difficulty is simply determining whether there's a latent print of any use, and oftentimes they are faxes of copies of copies of faxes of faxes of copies, and very poor quality records to compare to. Next slide, please. We started having an issue with this, though, because we are accredited to ISO 17025. We have voluntarily accredited our latent print unit to 17025, and here's the rub, that in our interpretation of many multiple standards under 17025, this exam on the stand thing is incompatible with accreditation. It's a poor practice, period. If you think about what's going on with that, it is the textbook setup of suspect-driven conclusion bias. You have just taken the suspect's prints, you are comparing everything with that knowledge there. Everybody in the room is looking at this of, we all know it's the guy, what's the problem here? But this is inconsistent with our accreditation standards. There's no review, there's no verification, there's no report, there's no documentation. You're basically giving verbal results without any of that happening. I did send a question about this to ANAB between 17025 and 17020 because the sheriff's office is accredited to 17020. I'm not that familiar with 17020. as we've been trying to sort this out, that we don't jam up everybody on what accreditation standards are where. ANAB's response, and I think that's predominantly the thing for the commission to be aware of, their response on this is basically that it is at the laboratory's level to do the risk assessment of this and could come to a conclusion of how they would handle this and basically construct their SOPs to refer to this as field testing, and you could do it in another manner. I am now kind of on the outskirts of this. This is still a huge problem in Harris County. It's really an issue across the entire state. My board on Friday, after a lengthy discussion at the board meeting, voted that we will not add this as effectively another service to HFSC. So it was a hard no from my board about doing this, so we're now extracting ourselves out of what we've been in on this. But I think the main thing is to make you aware of, this is an area of latent prints that occurs across the entire state, a practice that is challenging to see how it fits with accreditation. And there are certainly some subtleties between 17025 and 020 to be aware of. Fast enough?
So what we were surprised about, ANAB's response is that substantively on these questions, there's no real difference between 020, which is Harris County's accreditation, and 025, which is HFSC's accreditation. But what they said that surprised me personally is that one can have an accredited latent print unit, division within the lab, and write out from your SOP this work, which you can just say is field testing and is unaccredited. So I've always known that a lab can have both accredited disciplines and unaccredited disciplines under the same roof. That has been true for a very long time. But I didn't know that you could have an accredited latent print section and carve out work that you do in the field as field testing. But that's the answer that they came back with. And that ultimately it's a risk assessment for the lab that's doing it, whether they want to do it or not. Now, latent prints is exempt from the accreditation requirement by statute. So I'm not sure that we have anything that we can say or do about this particular situation. I do think it would be a different conversation perhaps if we were talking about seized drugs or something like that, and saying, you know, you can carve out testing that you do in the hallway at the courtroom as field testing. I just can't imagine any of our chemistry units being willing to do that. You know, HFSC is saying that they're not going to take on the work from the backlog. I think that's probably going to have major repercussions potentially, but I think the DAs, they're going to have to work out how to otherwise prove up these things, or I'm not sure if Harris County will get increased capacity or what will happen. DPS used to do pen packs for JNS, but then they stopped doing it. They declined to do it, both because they just said our accreditation standards don't allow it, and secondly because it was a massive resource drain for them with all the traveling around and things that need to be done just to roll the prints and do this analysis on the stand with a loop as your tool. So, questions? Okay.
Thank you. All right, item number 17 is an update from the Texas Association of Crime Lab Directors.
Guess that's me again. Yeah, we met for our, I guess, twice a year meeting, because we meet before this meeting and before the summer meeting. Not just a whole lot to update. We added a couple of new members, and I think the main thing that we voted is I will now go work with my general counsel to work on what is an appropriate incorporation function for TACLAD, because really right now it's, as I joke, 12 nerds in a room. We don't really have an official actual structure. And so to create that, because I know in the last legislative session, it was beginning to be important to help inform staffers of what TACLAD is, what we really are, and so that there's something to actually recognize that. So that's what we'll work on, I think, is the big part there. And also that helps set us up to be able to more effectively set up a website presence for the organization and more for just people to recognize what TACLAD is. Otherwise, that's kind of where we're at.
Anybody else have any questions? All right. All right, next is item 18, which is agenda items for next quarterly meeting, which we will carried some over. Anything we need to discuss on that?
So not for agenda items, because we'll have the same agenda, but I was thinking about checking to see the hotel across the street from where y'all stayed, the new one, that Hilton Garden, to see if they have the state rate. Maybe, I think it's nice to be close proximity-wise, you know, because it's not a big hall, but we could try that one.
Sure.
Unless anyone has an objection. We'll see if we can get the state rate there.
Okay. Sounds great. The
Since
next.
it's brand spanking new, we might as well see if it's.
The next agenda item is the schedule of the future panel and quarterly meetings. The next meeting is April 21st? 22nd, sorry.
We will send out a doodle poll for July.
Okay.
Other than that, just keep your eye out for doodle polls for the various panels.
Okay.
Please.
And the final item is any public comment. Do we have anyone? No public comment? All right, so that being said, do I have a motion to adjourn?
So moved.
Second? All those in favor, say aye.
Aye.
Seriously, anyone opposed?
Seriously.
Okay.
One announcement. Steve, thank you for all the video work. It's really a lot what he has to do. And he's taking headshots for anyone who wants a new headshot for the website. Steve will do that for you after this meeting. If you check out the website, if you don't like your headshot, you can have an updated one. I've insisted that Dr. Bernard get one done because his is so blurry. And
They can Photoshop yours.
if anyone else would like one, just let Steve know and he'll hook you up. Thank you.
Dr. Nord, I had one other matter. This guy to my right, Badoli, I learned this morning, is actually retiring next week. And I don't think the commission's officially blessed that or given approval to that. What do you think?
There's no motion to that. We're not going to.
And I'm not going to.
If we don't take a motion.
Either.
Well, there's people asking, how will you know the difference? So that's something we ought to study. Maybe a panel or a committee or something?
Now you know why I'm retiring.
Yeah.
This is the reason.
Yeah. Oh, congratulations. He's going to retire next week. I mean that.
Thank you.
Well, I believe that he's staying on to some,
Not from us, from his day job.
well,
Yeah, he's stuck with us still.
very good. We talked about it a little bit this morning, and he'll be working harder probably in his retirement than at work. All right, that said, everyone have a safe trip home.
Thank you.